dusty road where the old deals roam. Rode in pride and John, making houses their home. Lone stayed put while the deed changed hands. Sub to cowboys with a master plan. Subject to under western skies, keep the loan alive, let the deed ride by. No bank, no fuss, just grit and trust in the Wild West deals. It is subject to or bust. Then came Kyle with a steady stride. Hero cowboy riding equity wide. 3 men teamed up under desert sun, chasing freedom till the deal was done. Subject to under western skies, keep the loan alive, let the deed ride by. No bank, no fuss, just grit and trust in the Wild West deals. It is subject to a bust.
This presentation is for educational purposes only. American IRA, headquartered in Sioux Falls, South Dakota, is a neutral third-party administrator on behalf of the custodian New Vision Trust Company, a state-chartered trust company based in South Dakota also, and does not offer investment advice or endorsements. We are not responsible for statements made by others, and references to we and us refer to American IRA only. We encourage you to do your own due diligence and consult with qualified professionals before making any investment decisions.
Ladies and gentlemen, there you have it. It is going to be a great show that you are getting roped into today, and we welcome you to the Ponderosa of the IRA Cafe, powered by American IRA. I am joined on this side by Brian Elam and over here by John Hamrick. And why did you see that opening, and why do you see us looking like this? Because this is the way we are the most comfortable. And it's my pleasure to introduce in today 2 gentlemen who you've seen individually in their presentations, but together they are otherwise known as the Sub-2 Cowboys. And the reason that they are is that they are going to bring a presentation to you that talks about an investment tactic that they like to say is as old as the Wild West. It is a creative tactic that people can use their self-directed IRAs to invest in. And so today what they are going to do is they are going to explain what subject to investing is, which really where an investor buys a property, takes over the seller's existing mortgage, without formally assuming the loan. And I tell you, if you go back and watch any of the repeat plays of that intro, it's a really cool 60-second clip to show you what Sub-2 is. But now these guys are going to jump in and tell you everything you need to know about it and how they have presented it in the past. So again, we welcome Brian over here and John over here, and we appreciate them spending their time with us. We appreciate all of you joining us here at noon on the cafe and 9 a.m. on the West Coast and everyone else in between. So without further ado, gentlemen, take it away.
Thanks, Kyle. I appreciate that intro. I'm ready for the rest of the movie, by the way.
Yeah, really. I hope you're not disappointed by the reality, but we don't think so. We've got a lot of information, and we're going to get it to you as quickly as we can. And we will also answer questions as we can. And for those of you, it's past noon on the East Coast. If you want to have a drink every time I say, I don't have a problem with that. Just don't drive. So we are the Sub-2 Cowboys. We came up, there's a drink. We came up with this idea to help educate people on the pitfalls, try to keep everything safe and subject to investing. It's an advanced investing strategy, and Brian will talk a little more about that in just a second. But mainly to give you information, just enough, hopefully, to keep you out of trouble, but to give you an idea of what to look for and what some of the traps are, because it is the wild, wild west out there, as Brian's been known to say.
You want to read that? Take this one. So we are handsome and brilliant, even if you can't see it anymore, because we're all so old. But But John is an insurance professional, one of the best that I work with for certain, and certainly is interested in being as educated as possible and learning as much as possible about insurance needs and how things should be structured. And I'm an attorney, and just because that's what we do for a profession, that doesn't make us your insurance agent or your attorney. What we're going to talk about today, we're going to speak in very hypothetical terms, but also if there are any questions that we address, we are going to answer those as if they were a hypothetical question. So while it may be very real to you, we're not giving you particular advice. You'll need to consult with us independently if you would like to, or talk to your own insurance professional or attorney. There are bios on the screen. That makes us seem even older, John.
It does, but we are. And that means that we have had a lot of time to acquire at least some wisdom that we would like to share with you guys. So,
All right. Yeah. Talk about
Go
this, John.
well, the duties of a cowboy, you've got to protect the risk. And in this case, it's protect the risk from the buyer's perspective and also satisfy the mortgagee. You want to protect your investment using the right attorney and insurance agent. And then driving it home is making closing as easy as possible by making sure everyone is on the same trail. You really don't want to be thrown by the bull, so listen up.
All right. So subject to deals can be very lucrative, but of course, I've been practicing long enough that I've got some stories about how they weren't and how my clients lost money, lost the property, sometimes were threatened with lawsuits. I personally have never had a client actually get sued over a subject to deal, but I've heard it's happened.
So you want to know the advantages of this kind of investing, and you also have to know what the risks associated are with it, and decide if you have the tolerance for the risk. Last week, I talked about risk management, and so this is part of your risk management too. If you're adverse to riskier investments, then you have to think hard about this because this is not for the faint of heart.
All right, this is the most basic way that John and I could think about how to describe what happens in a subject to transaction. Actually, you saw it pretty well displayed in the intro video, is that the mortgage that's currently on the property is going to stay in place, even though the deed, the ownership of the property, is changing hands. And so there's a lot of vocabulary in there. John already talked about the mortgagee. Most people just call that the bank. That's the lender that currently has a loan on the property. What we see many times in these transactions is that there's more than one lien. People may have gone to North Carolina Housing Finance or to HUD to catch up their past due payments in the past. So there could be two liens there. Part of your due diligence is the same as every other real estate transaction. You're going to want to check out insurability, structure of the property, how much maintenance or deferred maintenance is there, and then also title, who owns it, what liens are out there. Another key issue and subject to deals are how much equity is in the property. And then that can be both a positive and a negative in these transactions. So you just want to know kind of what that number is. I always believe that a subject to offer from a buyer should be one of many. So you should present your seller with a cash offer. Usually that's a lower value because you're putting all of your capital into it. So there's some opportunity risk and negativity for you as the buyer. Then I would say a subject to, and then also if you had to go get a loan on your own. Now you may be able to offer more overall to the seller with a loan if you got one, but again, there's some cost to you going that route. And then you need to make sure you use a proper contract. You can't just write in on the standard realtor contract that you're taking a property over subject to the seller's existing loans, because it just won't work. The language is not designed for that type of transaction. Next, you're going to want to talk to an attorney. Again, that's part of North Carolina due diligence and closings, as we talked about last time. We're an attorney state. But in this particular case, especially with subject to transactions, for reasons that we get into actually later on when we go into more detail, you're going to want to purchase the property in a land trust or in a trust. That is where John's expertise comes in as well, because getting the insurance policy right has to be done in the beginning, and it has to be set up with a loss or a claim in mind. So, John, do you want to talk about that a little more?
Yeah, that's the insurance policy is typically the one thing that flags the lender that perhaps the deed has changed hands. And so there is a strategy to doing it the correct way. You want to make sure that you have the right policy. You need to make sure that the escrow is set up. If the insurance premium is escrowed, you need to know whether it is or it isn't. And usually most of that information can be gleaned from a current mortgage statement. And then you've got to manage the seller's policy. And I'll just give you a real quick tip on that once you have purchased the property, the seller's policy no longer covers the home. The seller's policy is more than likely a homeowner's policy, which contemplates an owner-occupied dwelling. And once the named insured has moved out of the home and no longer owns it, that policy does nothing for you. So don't proceed on the thought that policy is going to cover your investment in that home.
Yeah, I'm glad you brought that up, John. That's one of the biggest mistakes that I see people make with subject to deals, is they think it's better not to make any changes to the insurance and just let the escrow account keep paying the premium. But then when something happens, and right now we're in the midst of a winter storm in North Carolina, so, heavy tree falls on a house and there's a claim, guess what? That's coming completely out of your pocket because the insurance is going to deny that claim.
Now, there are times when it is beneficial to leave the seller's policy in place. That's usually on a fix and flip or something like that, where we may have put in place a builder's risk policy to cover the materials,
right,
and liability for the owner. But because that's not the type of policy the mortgage company or the lender is looking for, we leave the buyer's policy in place, and that's just so that we don't trip any wires, so to speak, any traps.
Hey,
Ryan,
John,
I just saw disclosures. Yeah,
yeah, I'll talk about that in just a second. But I just saw a comment from Haley. So sometimes people should be thankful they don't live in Tennessee, but it's rare. This is one of those rare times. In Tennessee, for those of you who don't invest there or don't know about Tennessee, unlike many other states in the union, Tennessee rental properties are often just owned in somebody's name. And that baffled me as an attorney, that they would not have the protections that are offered by corporate structure or by trust. And Haley knows it, understands why that is. The taxes are higher if you are a non-individual or single member LLC owner. So I'll be honest with you, I'm only licensed in North Carolina, so I don't know all the workarounds that there are for that tax issue, Haley. But you are correct. Not every type of ownership structure is going to be eligible for the tax benefit. What I will say is, like John talked about in the beginning, we've got to weigh out those risks. So the reason we use a trust structure is because it allows us to set up the insurance policy in a way that is least likely to trigger the due on sale clause with the current owner's lender. Now, that whole sentence sounds like a run-on sentence, but every word in it is important. And so really the reason for the ownership structure is to try and minimize the impact to the hazard insurance, which then minimizes the risk that the lender will call the loan due. So that's really what we're after. We've got to weigh out those risks, but that risk may be bigger than the negative impact of higher taxes. So thanks, Haley, for that question. And I'm glad you're familiar with the issues that face Tennesseans in owning investment properties. All right, John mentioned the disclosures, and those are very important. And quite frankly, I've had clients before. I get an angry phone call from an attorney who's heard from a seller, and I call it seller's remorse, where they've entered into an agreement with my client to sell their home subject to their existing loan. A few years have gone by. My client's doing exactly what they promised they would do, making those monthly payments. But now they're at CarMax and they're trying to buy a car. And the credit officer's telling them, we can't give you a car loan because you still have a mortgage in your name. You've got too much debt. So the next step is they get angry about it, ends up in a lawyer's office, and the lawyer contacts me. And I asked the lawyer, I said, well, did your client tell you about all the disclosures that they signed, acknowledging that they understood what was going on in the transaction, what the risks were? No. So you haven't seen any of the paperwork? No. I said, let me send you the paperwork and then let's talk again. So I'll send the paperwork over. About a week goes by and I hear from them or I call them back. And usually it's some version of, well, this looks like they understood everything that was going on. And the answer is yes. That's exactly what you as the investor want to make sure of, is from the very beginning, you want to start disclosing to the property owners all the risk and issues of which you are aware. You don't have a legal responsibility to do that, but it's a practical issue. If you want to minimize the negative impact to you on these transactions, then you will disclose. And we actually even have a disclosure that you can attach to your contract. We call it the subject to disclosure, that right from the beginning explains to them what they are considering violates the terms that they entered into with their lender. It's going to remain on their credit even after they've sold the house. Now, for most people, that's a positive because they've been missing payments. You're going to catch them up. You're going to start making them on time. That's actually going to improve their credit. So just make sure that whether you work with our office or not, that from the very beginning, from the signing of the contract, you make sure you disclose in writing, signed by the property owner, exactly what the nature of the transaction is. Which takes us into closing. Again, make sure that you are using the right forms, and you can't just handle this like a typical transaction or a cash transaction where you walk in and sign a couple of pieces of paper and walk out. There has to be a lot more paperwork, because what happens is most of these go along and work fine. Everybody's expectations are met. There are never any glitches. But when there are issues, they're major issues. So we want to make sure we've got all the paperwork and forms in order.
And Brian, I would mention too, because I've heard you say it over and over and over, this is not necessarily a long-term investment tool.
No, I would all from before closing the transaction, from before buying the transaction, as an investor, I want to make sure I know how I'm getting out of it. Whether that's by selling the asset, refinancing the asset, or paying off the existing mortgage in a lump sum. And I do have clients that have had subject to properties for 10, 20 years. It is possible, but it's risky. And so you just always want to make sure you've got a few different exit strategies.
Very good. Do you want to talk about the Home Foreclosure Rescue Scam Act?
Well, it is one of my least favorite things. That is actually the name of it, folks. So the North Carolina legislature passed a piece of legislation called the Home Foreclosure Rescue Scam Act. I believe names make a difference and names matter. That tells you what that particular legislature thought of investors who enter into these types of transactions. So that act is specifically related to subject to transactions, and it sets out all kinds of criteria that you've got to comply with. So one of the biggest ones, and this one I'll bring up because you need to understand it as an investor, but one of the biggest ones is that the seller cannot retain an interest in the property. And so what we'll see a lot of times is that, the seller comes to the investor and says, well, I'll sell you my house, fine, but I can't move into my new place for 2 weeks. Could I live here for 2 weeks after you buy it? And the answer is no. We can delay the closing. We can do all sorts of things. And many times what we find is that these sellers are strapped for cash. And so they don't have the money to move until you buy it. But then they're not allowed by statute to stay in the property after you buy it. So what do we do? That, again, is developing a level of trust. There are legal things that we can do to where you could divert some funds to that seller before you actually purchase the property, and we could secure your repayment. That is, if subject to is highly advanced, that's like 3 more rungs up the ladder. So the biggest advice I can give to you on that act is beware of it. Don't let the seller stay in the property after you purchase it. And if they need financial help to get out before you purchase it, talk to your lawyer and make sure they've heard of the Home Foreclosure Rescue Scam Act, because they probably hadn't. The penalties for violating it are pretty severe. Some of you may have recognized that that's in Chapter 75. That's within the unfair and deceptive trade practices statutes in North Carolina. So there's treble damages. That's 3 times. So if they feel like that you were damaging them by $10,000, their recovery is $30,000. There's punitive damages and attorney's fees that are all calculated in there. So really, really very serious issue that we need to make sure that we address in these transactions.
And we do understand that we have a national audience in this webinar, and most of what we're talking about deals with North Carolina law. So make sure to contact an attorney where you live and find out what the state laws are there. Insurance is also regulated on a state-by-state basis. So what's good in North Carolina may not be the same in South Carolina or the same in Tennessee or Georgia or Virginia. I can attest to that. So make sure to contact someone that's knowledgeable on this. And if you have to explain what a subject to deal is to an attorney or to an insurance agent, they're not the right people to work with.
Yeah, I would agree with that. And actually, we have an international audience today. Somebody just said hello from Malaysia. So
Malaysia.
Welcome back.
Right.
And I will say laws to your local jurisdiction apply. Also laws to the jurisdiction where the real estate is applies. So sometimes you have to talk to 2 different professionals.
Exactly.
All right, John, I'll take this one since this is really kind of what we do as part of our due diligence. But you want to make sure you're doing an initial property search. I suggest as an investor, check behind me. Actually, usually check in front of me. So before you even execute a contract, you should be figuring out the position and condition of your seller. How old are they? Are we talking about an old widow that has adult children? Because you might need to get the children on the phone before you start contracting with the old widow, because they know her a lot better. And they might be really upset if they thought they were going to inherit the house and they find out mom got rid of it. So again, you want to know about their capacity. You want to know, why are they selling? What are their capital needs? you want to ask the seller how many liens they think are on the house. They're normally wrong about it, just by the way. They don't necessarily know all the liens that are there, but you can ask them. A way that I like to ask is asking them, who do you write checks to each month? And that'll let you know a lot of times, because they might say, oh, yeah, I write a check to, Brian's Heating and Air. And you would think, oh, well, that might be a lien on the property. Maybe she got a new heating and air system. It's going to create more questions for you to ask the seller. Also, you want to inspect the property. Now, I will tell you, don't insult people. They know that there are problems with their house. Every house has problems, even the one that I live in. Probably because I just sometimes don't feel like I have time to fix them. But they do. They have issues. So if you walk around pointing out every little water stain, every little floorboard that's out of whack, they're going to get offended. Really, what you can do is compliment them on a beautiful home, talk about the memories that they probably had there, and then say, I need to do my due diligence. And then you need to kind of run the numbers on what it'll take to fix it up to the proper level. On this, I say contact the seller. Boy, again, I keep talking about how old we are, John, but I find that we live in this strange world right now. My church just released an app, and I have duplicitous feelings about it. So it is nice. It's good. It's convenient. They're daily devotionals and all types of things. We can be connected to each other digitally now through the app. But I'm concerned that we're going to lose some of that face-to-face or over-the-phone connection that we have with people. And I say the best contact with a seller is in person at the property if you can. And the second best is on the telephone. But the reality is you can learn so much about people speaking with them face-to-face. We have this whole unspoken language, body language, that allows you to really learn and understand a lot more about people. If you are not a member of your local real estate investors association, you should become one. John and I each sit on the board of a local real estate investors association, and it's a chapter of the National Real Estate Investors Association. But these associations have networking opportunities, but also practical tools that will help you make these offers and understand how to do that. All right. I think we're done with that one, John.
All right. So for due diligence, you're going to want to contact a contractor that you would use, get estimates. As Brian was saying, with our local Real Estate Investors Association, we have a place on our website where you can estimate costs of repair. Wouldn't hurt to get more than one estimate so that you're pretty sure. But if you've got a contractor that you're going to use, get it from them, and everything should be good. A current monthly mortgage statement. That is so important. And Brian will tell you that that's important because that's going to tell you how far behind the seller is. And it's not always a case of someone being behind, but maybe somebody just their circumstances have changed. But that tells you exactly how much cash you're going to have to send to the mortgage company to get it caught up. It is also going to provide information that I, as an insurance agent, can use. I can generally tell from that if the insurance is escrowed, if the taxes are escrowed, what the mortgagee clause is, who's on the deed of trust, which is a big thing for the insurance piece. And that way, if you have that information, can share it with your insurance agent, that'll help your insurance agent get started on it. You're also going to want to get authorization to access the account from the seller. And I'll let Brian talk about the different types of powers of attorney that you might get, whether you want a permanent one or what.
Yeah, absolutely. And before this, Kyle actually presented a question referring back to the Home Foreclosure Rescue Scam Act. And Kyle, just to make sure I gave you the best answer, not just an answer, pulled up the actual statute. And what the statute says is the transferor, that's the seller, retains a tenancy interest, an interest under a lease with an option to purchase or an option to reacquire the property. So it's not even just about being in the property. There are certain other legal things, but I'll be honest with you, I have not seen any cases tried on this. So the most conservative way that I know how to explain it is just to tell them, no, they can't stay in there at all. They got to get moved out. I'm coming to pick my clothes up next week. Nothing. It's got to be out. So that's just the safest way.
Gotcha. Thank you.
All right. Now I have to remember what John said. Oh, John was talking about powers of attorney. So I believe the thing that's the least overreaching is to do a limited power of attorney. Not necessarily limited in time because you don't know how long you need it for, but limited in scope. So we're going to limit it just to the particular property that you are acquiring from that seller. We had this come up. I've got a deal, and actually it touches on several things that we talked about. I've got a deal coming up with a client. We originally did the subject to transaction in 2013. He still has that property, still has the original loan on that property, has no idea where that seller is. Now he's selling it. One of the reasons he's selling it is because the mortgage changed hands, and he just got a love letter from the new mortgage place, John, that says, we noticed on your hazard insurance, there's a name there that's not the name of our borrower. Explain yourself. And that's the letter you'll get. That's the first tremor where the lender's saying something's not right here. So we're dealing with one that's 12 years old, and we're in the process of trying. He has gotten it under contract to sell, and that should rectify all the issues, but we're trying to make sure we can get a payoff. So getting a power of attorney and an authorization to release, because I know it's dumb. I know the lender is supposed to take a power of attorney, but we've had situations where the lenders look at the power of attorney and say, well, this is good and all, but we don't have an authorization to release from the borrower. So we're still not going to talk to you. So we do both. We get both an authorization to release, one that doesn't expire, and a limited power of attorney to help handle those transactions.
Brian, and this may come up a little bit later in our presentation, but since you brought it up, if you get a letter from the mortgagee or the lender that has something to do with hazard insurance, don't try to answer that question on your own. Let your agent answer that question. I have a certain way that I speak to them, and I don't mention names. I just explain that the seller has put the property in a trust, therefore the trust is the named insured. The person on their deed of trust for record purposes is listed as an additional insured on the policy as their interest may appear. And they're just let me or let your agent answer those questions. You're not an insurance agent. How can you be expected to explain why a policy has come in the way it has? Let the agent who wrote it explain that, and that's going to better your chances of not triggering the due on sale clause.
And the reality is the policy may have come in the way it did because a mistake was made. And I know, John, you've seen this before where you submit everything with the way it's supposed to be, and the underwriter generates a policy in a different way. So I agree with you. The particular investor is just not qualified to answer those questions. So make sure you have an agent who's competent to talk about those things, but also willing to talk about those things. The number one rule, however, is never, ever, ever, never lie to the lender. So don't try and talk around it. Don't make things up. Don't stretch the truth. Don't do all those things, because that's when you'll start getting in really big trouble. You just need to be honest and upfront with the lender. And if you did your due diligence right in the beginning, you've already got a couple of exit strategies planned out. So if the lender gets mad about it, just execute one of those exit strategies. Maybe you left the investment earlier than you had hoped, but you didn't lose it.
Exactly. Start talking to your insurance agent. You should really start talking to your insurance agent as soon as you're ready to make an offer, particularly during the due diligence period, because sometimes in going to a problem, potentially problem property, is that I may be able to find out that there have been multiple claims filed, because we know that people who are under the gun financially tend to file more claims. That's one of the statistics that insurance companies use when they price insurance. So it's not necessarily a matter of the size of the claims, but it can also be the frequency of claims. And if you are talking to a seller about a property that has a lot of claims on it, you may have a hard time placing insurance. And I think most of you would rather know that during the due diligence part than 3 days before you're scheduled to close. Also, there can be issues with the property itself. I know that recently Brian and I worked on a purchase within an IRA, and I went in to quote the property, couldn't complete a quote because the insurance company notified me that they took an overhead, maybe a drone photo, it could be a satellite photo, but anyway, there was a trampoline on the premises, and those are hazards that the insurance companies don't want, and so they would not even offer to provide a quote on it until that trampoline was proven to be removed. So here again, I'm having to prove a negative, which a lot of times is difficult to do, and it takes a little more time. So as soon as you feel like you're going to make an offer or you're in your due diligence period, go ahead and contact your insurance agent and let somebody like me start helping you with how this is going to work. And also, it's always great to know what your costs are going to be going in so that you can make a rational decision on whether or not this is a property that you really want to purchase. I think on the PowerPoint, there may have been one more question. Yeah. Know what you want to do with the property. Sometimes I get requests for insurance, and the first question I'm going to ask is, what are you going to do with the property? Are you as soon as you close on it, are you going to market it for a tenant? Because that's going to require one type of policy. Are you going to fix and flip this? Because that will require a different strategy, a different insurance policy. And that's the case where we may want to leave the seller's policy in place. And just a note on that too, if you do a tenant occupied policy, you move a tenant in there, as soon as you buy it, and we're going to put a tenant type policy on there, and we want to try to coordinate the start date, which should be the date that you close or records, policy to protect your interest. And at the same time, we want to cancel the seller's policy so that when all of that stuff finally shakes out with the lender, the assumption is they've changed insurance carriers, and I can help explain that. But also know that any refunds from any canceled policies by the seller are going to go back to the seller.
Yeah.
And so you may want to address that in your contract, depending on how much money you're talking about. There are homeowners policies written now that are in the $3,000 to $6,000 range just for a decent house. And that's a good chunk of change. And if you think that should go back to you because that's what you agree to do, then that needs to be addressed in the contract as well.
Yep. And then Kyle said another question had come up asking whether I think these subject to transactions are similar to tax lien investments. And I would say in most ways, no. Tax lien investments are definitely very highly controlled by statute. Usually there's some type of county or city jurisdictional lien that's governed by a state's legislative structure. They have similar applications, though. I imagine this is going back to the residence of the taxpayer in many cases. So there's certain, each state is different in how they handle tax liens. For instance, in North Carolina, you can't buy a tax lien. In South Carolina, residents can. In some states, out-of-state people can buy the tax lien. So it's just different given your particular state. What a subject to transfer, though, is concerned about is a voluntary transfer of the property owner, understanding that the liens that are currently secured by the property are not going to be paid in full when they sell. So that really is what it's about. All right, John, sorry I jumped the gun on you there.
No, that's okay. And I kind of jumped the gun on the next slide. And these are the steps in the insurance process. Like I said earlier, you want to make sure that you purchase a policy that protects your interest. Don't try to save just a couple of dollars by thinking that the seller's policy, as I said earlier, would cover you, because it will not. In case of a claim, the insurance company is well within their right to deny coverage, and all they will do is return the premium to the seller, and it'll be as if the policy was never enforced in terms of your interest in that property. Try to coordinate the cancellation of the homeowner's policy and the new policy for you. It's generally, we like to do those the same day so that there's not a lapse. And there's a strategy in how that does, but it needs to be set up, how we do that, but it needs to be set up ahead of time. And I generally like to have the cancellation go through, have the confirmation of cancellation, know what date that is. I usually wait a few days before I issue the new policy, because if it is escrowed and our new company sends a bill to the mortgagee or the lender before the prior policy is canceled, they're going to send a message back saying, hey, we have already paid premium for a policy on this property. We don't understand why we're getting this bill. And then we have to explain something that we shouldn't have to. So I get the application signed, and I generally hold those for a few days after the cancellation has gone through before I issue. Because you'd be surprised how quickly an insurance company can get a bill to a lender.
Well, they want to get paid.
And a lot of times, just last week, I got a message from one of my clients, and the lender had sent a letter saying that your insurance is canceled. This was a sub-2 deal. Unfortunately, he didn't contact me before he did that. And so we had to scramble. And in the meantime, he paid a huge amount of money to protect the lender's interest in the property. And it absolutely provided him no coverage whatsoever. And so, if you have 1 or 2 days, where there's a lapse, we can slide. But I'm telling you, if you had a lapse over the past weekend when we had ice and sleet, that's not a good time to have it. Plus, it's really difficult to issue a new policy if you have a pending claim or you have damage to the property. So communicate. If you have a good communication with the bank, let them know that you're going to change the insurance policy. If you're not sure how that's going to work, don't do it. Let the agent do that. And if you get any kind of request that, as I said earlier, that comes from the lender that has something to do with hazard insurance, send it to your agent and let them respond to it. That's going to minimize your chance of discovery that their client no longer owns the property.
Yeah, absolutely.
And, how to talk to the mortgage company. I'm going to tell you the simplest answer is to keep it simple. Don't give them any more information than what they ask for. And this is if you're forced to speak to them. Only give them as much information as they need, and don't feel like you have to explain everything. And if it's getting in over your head, tell them, you know what? My insurance agent has a great understanding of how this policy works. I'm going to let you talk to him if that's okay. And then the agent can try to handle that on your behalf. Examples of what I would say to a lender is they come to me and they say, we have this policy, it's not in our insured's name. And I say, or it's not in our borrower's name. And my answer is the property's been put in a trust. I don't say for whom or by whom. And other things that you can say is we are switching insurance carriers or agents. And of course, the third thing is I don't understand what you're asking me. Can you talk to my agent? I keep getting ahead of these slides, Brian. I'm just, I don't know if I'm old or not.
Well, I know the answer to that, John.
Yeah.
So here's the other thing, and I would say this is true even with a normal closing. Honestly, I know it's tough to believe, but John and I work on more than one file for more than one client at a time, and we have to, right? I mean, there's just there's a lot to do. So I never get frustrated. And honestly, my staff does not get frustrated if people call, if our clients call to make sure everything's in order. We would rather hear from you. And quite frankly, we feel good when we're able to say, no, we're all ready to go. There's nothing more to do but show up with your pen. Actually, we have pens that you can take. But I would just say that's a good rule of thumb for everyone, right? You're the investor. This is your deal. You're standing to make the most money off of it more than any professional that you're using to accomplish the transaction. Make sure everybody's prepared. Make sure the seller's prepared. Now, not every state does this, but in North Carolina, when you say I do, you're really saying I will. And you're going to need your spouse to come no matter. So just kind of plan on them being there. We'd rather the spouse show up and not need them. We've got plenty of room in the conference room. Also, your attorney should be getting you numbers pretty quickly. Now, our goal is to get an estimated settlement statement out within 48 hours of getting the title work completed. Now, I'll tell you, we don't always hit that goal, but we do try and get people numbers as quickly as possible because that's what everyone else is concerned about. While I may be concerned about the title puzzle, they're concerned about the money. And both the investor who's trying to figure out how much is this going to cost me and the seller who's trying to figure out how much money do I have to move on with my life. The other thing is just because it's a subject to closing, just because the loan is staying in place, doesn't mean it's not a closing. We've had some heart-stopping moments for our clients where they call me years after they did a transaction where they just started making payments for a seller, and now they're trying to sell the house and don't know where the seller is. So they never did any paperwork. They don't actually own the home they've been making payments on for over 2 years, and now they're trying to sell it. And I got to tell you, that is very difficult to wind up properly and is very expensive to wind up properly. So it's better to just deal with it up front the right way in the beginning.
Yeah. And again, remember that your insurance agent is a member of the team. We try to get everything set up well ahead of time so that we're ready, just like Brian said, with the attorney side. The difference is you and the attorney know that it's closed. You need to make sure you let the agent know that it's closed so that we can talk about the coordination of policy cancellations and policy issuance. So don't leave your agent out in the cold. make sure that they're made aware that the property did close. And again, once it closes, that property is your asset, and you want to make sure that you have protection for that asset if that's part of your risk management story. So please let your agent know that it closed. And one of the things that I love about Brian is that his office will send me something telling me that it's going to close on this date when they have it scheduled. And so I put it on my calendar, and then it's just a matter of me sending an email to somebody saying, hey, I just want to confirm that this closed today so that we can get the policy in force and make sure there aren't any issues. Because, Brian, have you ever delayed a closing because something didn't work out at the table?
Yes. Usually we're not the ones delaying it. It's a lender, it's one of the parties, but yeah, they do get delayed all the time. We just had, so far this week, we've had 3 closings get delayed. What day? It's only Wednesday. That's one a day.
Yeah. So, so you close the deal. Now, do you ride off into the sunset, right?
Only in our movie,
no.
John. Yeah,
Only in the movies. That's right. Anyone who's ever done a subject to knows that these things take constant ongoing maintenance. So you have to, again, once you close, it doesn't mean that you're finished dealing with the mortgage company. You're not finished dealing with the insurance, because things can come up. And I do, I hate to say what my record is with subject to, because I don't want to jinx it, but I do have things that come up 2 months, 3 months after the closing, and I have to contact the mortgage company or the lender and explain to them why the policy that we put in place is the proper policy. And I usually just handle that from an insurance point of view, not from a deal point of view. So it does require ongoing maintenance. At some point, you may have to resort to one of your exit strategies. At some point, the seller may just get angry about thinking about what happened and what they gave up, because once you've caught up the mortgage, it becomes a good house again for them. So just know that things can creep up, so don't lose track of what's going on with it, and let us or your agent or your attorney help you. It'll be worth the cost going forward. We are close to being at the end of our hour with you guys, and so we want to thank you for listening to us. We want to see if there are any additional questions that we can answer. This slide has our contact information. And again, we are not acting as your agent or your attorney, but are just trying to impart some of the wisdom that we've acquired over the years, even though we're not old.
Yeah. And one final thing I'll say about riding off into the sunset, John, is that the clients that we have had that have been the most successful with these subject to transactions put on their calendar at least once a year, they contact these sellers. Now, thankfully, I've never gone through a divorce, but what I have heard it's like is when you are divorced and have children together, you're going to be in a relationship with that other ex-spouse as long as the children are minors. And because you're going to have to make parenting decisions together. And a subject to transaction is similar to that. The seller's loan is the baby, and you are going to need to stay in relationship with that seller for as long as that loan is in place. And so go ahead and prepare yourself to continue to interact with the seller of the property. This is unlike other transactions where you can forget about that seller the day after you close, because your interaction with them is potentially over. So you're going to want to follow up with them routinely.
I would say, Brian, from experience, that you're going to be involved with your ex-spouse until all your kids are married off.
Oh,
So,
wow. So that's even longer than just young.
well, well, it could be, but think of that as a term for your exit strategy in the subject to deal.
Yes.
That when you marry
married
off, get them married off, right? So put them in someone else's hands to look after. Doesn't mean that you don't stop watching. Kyle, do we have any questions?
Well, guys, I greatly appreciate it. I know that we interjected a couple in the presentation today to kind of keep it germane to that slide there. So great that we could get that in. And a couple of things that I will say to everyone is that Brian and John and even me, we're here in North Carolina. We're in the Triad of North Carolina. As you heard Brian talk about when he asked about or mentioned Haley's property over in Tennessee, or her knowledge of Tennessee, is that attorneys are very quick to say, well, I'm only licensed here, or I'm only licensed in this state and this state. So he's not going to speak on the particulars of states half a country away. And as all of you know who are joining us today, you joined us from all over. Right. And so even though you may not have their representation, I can't speak enough to the abundance of information that I gave you that they gave you, because the sub 2 is still the common denominator. That's the investment that can be made wherever you are. So if it's something new to you, if you're able to take this information and have your attorney and your insurance agent and whoever is involved in the deal, remember that they really need to be they need to understand this knowledge that you heard today. It's the same as we always say for folks. Look, we're not permitted to give any tax, financial, or legal advice, suggestions, or opinions in any way. So you want to make sure that when using your self-directed IRA for any of these investments, that you're surrounding yourself with a team of not just those professionals in that arena, but that they are professionals who understand the nuances of self-direction and really the creative deals within. We've always talked to folks that there are creative things that you can do with your self-directed IRA, and you got to hear one today. Very rare do we get to bring you these types of things, and so we are really overjoyed that the guys were able to do this for us today. And it's actually the type of topic where they covered the sub 2 in its generalities and some of the things to consider. Well, there's also one of the things to consider about really delving in and what that will be like with a self-directed IRA. And some of us back here on the ranch are already talking about the possibility of having them come back and really talk about this topic inside of the self-directed IRA. Gentlemen, together, we greatly appreciate you. I know that we have pushed a little bit past our time today, but that's great. It also means that we're bringing a lot of information here. People have been engaged. As always, we appreciate everyone who has attended today, no matter where you are. And I will tell you, I'm already still thinking about that opening trailer that our team put together there. And for any of you that missed it, or if you want to see it again, just remember, you're always going to be able to catch this webinar and other of our publications on YouTube. So find us there and subscribe if social media is your thing. You've got Instagram, you've got Facebook out there. Find us and like us. You will always be kept up to date with everything we have. And then also finally at our website itself, American IRA at www.americanira.com. You'll always be able to find all the latest information, all the education that we can have out there for you. And if you're ready to go ahead with your new account, you can see me there looking a little different without the beard and the cowboy hat on, but it's still me nonetheless. And I'm always here to answer your questions and to walk you through the application so that you can enjoy spending time with the rest of our team and move on to your transactions. So AmericanIRA.com, YouTube, Instagram, Facebook, we are everywhere that you want to access us. And for next week coming up, well, actually right here, before that, let me tell you this. If you do want to schedule a consultation with me, I'll be more than happy to talk with you. We're going to leave this up a second here. Make sure to scan that QR code, and that is going to get you in touch with me or with someone on our team. We'll be more than happy to take care of you. Coming up next week at the cafe, we are going to be joined by Rob Stanley and his business partner, Clay, Shining Rock Investments. And they're going to be bringing another great presentation. If you've seen them before, they have a great Shining Rock Equity there, and they have a great presentation that they will bring. And I know that they wanted to do something for Q1 to bring something new to everyone to be able to see heading into 2026. So again, for everyone that has joined us today, for anyone who has joined us in the past and who's already looking forward to next week, we always thank you. We're here for you. And until we meet again on another episode of the IRA Cafe powered by American IRA, I'm Kyle Moody saying, see you then.